if you are, a competent and professional kind of prosecution barrister, or indeed whether even if you're employed CPS prosecutor or post office prosecutor, as the case may be, or any other prosecutor, your obligations remain the same. Your primary obligation is to justice and to the interests of justice and to transparency and honesty with the court. The primary obligation is not to win the case come what may and to try and deprive the other side of relevant evidence, disclose it. So your professional duty and legal duty is absolutely clear. You cannot allow the court to be misled. The prosecutor's duty is to ensure that there is full and proper disclosure. If the prosecutor cannot satisfy himself or herself that there can be proper disclosure, there's only one option: drop the case. In that scenario, most judges would step in and say, okay, I want you to tell me whether you are satisfied as the prosecutor on the record that you can properly prosecute this case and discharge your disclosure obligations. If you can't, that's end of case. It's an abusive process. The case stops here. And that's what should happen in that situation. I have to say, the idea that a contractual obligation would override the disclosure obligation in a criminal proceeding is nonsense anyway, because no contractual obligation could possibly be enforced. It would be an unlawful contractual provision for a contractual provision to say you must not disclose material to a criminal court in the context of criminal proceedings where such disclosure is necessary in the interest of justice. That just wouldn't be an enforceable provision in any contract anyway.
Would it be reasonable to say, Chris, that a careful prosecutor would have a chain of their own evidence of this sort of inquiries they've asked of their clients
absolutely.
Yeah.
Right? I mean, not just a careful prosecutor, any competent prosecutor. I mean, you have to have an audit trail of everything that's been done on the investigation, and that log that I described, at what's called a schedule of unused material, that's the kind of audit trail of really what's been gathered. And that even includes things like, if you have emails between an investigator and a witness, or in this case, between the investigators and the software company, those emails themselves need to be included. Criminal prosecutions are human affairs, and they're susceptible to human error. The post office scandal, I have to say, looks a lot more like cover-up than human error as far as I exist. And the obligation post-conviction on any prosecutor is to disclose anything which might reasonably be expected to give rise to a successful appeal. If the position, as we understand it, is right, that as early as 2013, the post office was aware that that many had been convicted on the basis of unreliable evidence, which was central to the case, and that's really quite important. Then the obligation was to immediately write to anybody who conceivably may have been affected, making complete and transparent disclosure of what had happened, and suggesting that whoever the defendant was should seek legal advice with a view to a possible appeal. If a prosecutor becomes aware that a conviction is unsafe, then that prosecutor, can and should take steps to reverse the position and reinstate the person to the status they should have had as much as possible, i.e. that they shouldn't have had the conviction. It should be quashed. We're all bound by the criminal procedure rules and our own professional obligations, which, as I say, are first and foremost to the court and to the interests of justice. And so we're not entitled, or nor should we, on either side of the fence, kind of just use and abuse the various applications and systems available to us for improper kind of ends. The system only works if prosecutors in particular, but also defense lawyers, act responsibly and follow the obligations upon them. So if any lawyer colludes with the withholding of evidence or the making of spurious applications that are going to waste the court's time, then that lawyer is part of the problem. Often the defence will raise a fundamental technical issue with the prosecution evidence, whatever it may be, whether it be computers, mobile phones, some other form of technology, scientific testing, around whether or not that particular method is reliable. So, take, for example, if you're testing drugs, is the machine calibrated properly? Is it reliable, and so on? When the machine says, yes, this tastes positive for cocaine or heroin. So I'm taking it away from the specific, but the principle is the same, and so there'll often be queries raised by the defence, and the defence will ask for access to reports on the testing of the system and technical specifications and other sorts of information of the equivalent kind to the one that would have been relevant in the Horizon Post Office software issue. And then what if you are a competent and professional kind of prosecution barrister, or indeed whether even if you're employed CPS prosecutor or post office prosecutor, as the case may be, or any other prosecutor, your obligations remain the same. Your primary obligation is to justice and to the interests of justice and to transparency and honesty with the court. The primary obligation is not to win the case come what may and to try and deprive the other side of relevant evidence. So if an issue of that is raised, what tends to happen is you get varying degrees of enthusiasm for it on the part of prosecutors, depending on sometimes the identity of the person making the request, because there are defence lawyers who sadly do abuse the disclosure process and go on fishing expeditions to just try and find anything that may conceivably help the defence case with no proper basis, just as a sort of wild allegation that it's not working, but with no actually basis to make that point. So there has to be a degree of sort of challenging and filtering around whether the request is a real genuine one or if it's just an attempt to derail the prosecution by getting the prosecutors tied up in endless disclosure exercises, which may in the end prove to be a complete red herring. So, but what would nevertheless happen is that if I were in that position and I were prosecuting a case on behalf of a government agency or any other organisation, I would look at the request. I would look at whether the disclosure request or the point that was being made actually made sense. Is there potentially something to this, or is it just a long list of stuff we want without any real kind of attempt to analyse why it might be relevant or how the issue arises. And if I didn't feel that it was a vexatious or frivolous disclosure request, I would be saying to those instructing me, so the solicitor, as the person leading the prosecution, the one who's got to go to court to present the case, whether a QC or junior barrister or solicitor or whatever, it's ultimately your responsibility to do your best to ensure the court will not be misled. Because it will come back on you if the court is misled and you had information that you could have given to the court and you didn't act upon it and didn't disclose it. So your professional duty and legal duty is absolutely clear. You cannot allow the court to be misled. So I would go back to my instructing solicitor and the investigators, and I would say, look, this issue's been raised, that this technology doesn't work this way, and it's known not to work this way, and that there may have been testing that establishes it has faults. I need you to go in. I want a written report telling me whether there has been testing, what the results were, and whether there's any suggestion that this particular testing upon which we, the prosecution, are relying to prove the case is in some way flawed. And I would expect to be told the truth. And if I got a report back, or if I had a meeting and sat down with the investigators and I was unsatisfied and felt that maybe they hadn't looked into it enough, or there hadn't been sufficient care given to the process, I would send them away again and make them do it again and come back until I was independently satisfied that I know everything that I could possibly know. Now, of course, that depends on those beneath me, so to speak, or those in the team being honest and open with me as counsel, and that doesn't always happen. And that's why it's always a dangerous thing to start to blame the advocates, because the advocate isn't the one that actually goes and investigates and gets the evidence and so on. And we as advocates, when we're prosecuting in cases, we are relying on the investigators and our instructing solicitors in particular to give us the ingredients and the information and tell us the whole truth. So if the scenario comes back, they say, so no, we've looked into it and there's absolutely nothing, then to go back to your sort of three-stage process, as it were, that's what I would tell I would say, okay, well, then you need to write to the defence and say, made inquiries and there is nothing. And when they raise it with the judge, I would have to stand up and say, we have made extensive inquiries and nothing has been revealed and there's nothing to disclose. And the judge has to trust us because he hasn't really got any choice, because we're the only ones who have got access to the information on the prosecution side. And that's why it's so crucial, that obligation on prosecutors, independently of the interests of their client, if they're privately prosecuting, independently of anything, the obligation to be open about what you have in your possession is so fundamental. So the next thing comes about is, let's say that there's a further disclosure request, and this time the defence say, well, here's a letter from Mr. X, and he used to work at the company that makes these machines, and he says that there were 6 tests in over a 3-year period, and it showed that it was faulty. What I then do is I go back to my investigators. I say, look at this. It's got detail. It's got dates. You go away and come back and tell me. And then let's say what happens is that they come back and they say, okay, we've made inquiries with the manufacturer. And the manufacturer said, yeah, these were just calibration errors. There wasn't any issue with the output. It doesn't affect the end result, etc., etc. So, and I go, are you absolutely sure there's nothing? Okay, there's nothing. And I get a written report to that effect. Same thing will happen. Write to the defence and say, we've looked into this. It was calibration errors. It doesn't affect the end result. It's nothing to disclose. Nothing undermines the safety of the evidence. And that's what I would tell the judge. I'd go to the judge, and the judge would say, have you looked? Yes, I have a report. There's absolutely nothing to disclose. We're terribly sorry that we didn't tell you this before, but it wasn't really relevant. And here's the answer. Actually, there were some calibration errors which were resolved immediately, and it doesn't affect this case at all. So then you have, that's the second of your 2 scenarios that you described in the post office case. And at this point in time, counsel's done nothing wrong. Counsel's just followed the process and done things properly. And then what happens is that there's further pushing, and I get another report back that says the manufacturers have said that there are issues, but they're not going to disclose them to us because our contract says that we're not entitled to see them. Now, that's when it becomes very interesting, because at that point in time, the prosecutor's duty is to ensure that there is full and proper disclosure. If the prosecutor cannot satisfy himself or herself that there can be proper disclosure, there's only one option: drop the case, offer no evidence. What you don't do is you don't go into court and say, there may well be material that would help the defence and undermines the defence, but we have no contractual right to it, so we're not even going to get it. In that scenario, most judges would step in and say, okay, I want you to tell me whether you are satisfied as the prosecutor on the record that you can properly prosecute this case and discharge your disclosure obligations. If you can't, that's end of case. It's an abusive process. The case stops here, and that's what should happen in that situation. And how inaccurate information may have been conveyed to the court really depends on who knew what in the whole chain, going back to Fujitsu and going back through up to the advocate who stood up in court and said what he or she said. So somewhere along the way, information has not been fully disclosed, and often it's quite difficult to track down exactly where in the process the process failed. But I know that there was significant criticism in the post office case of Fujitsu's kind of lack of transparency along the way as to flaws in the system. But once again, that is an issue that it will arise where the primary source of evidence is a private company, Fujitsu in this case, which has no obligations in the disclosure process at all, because they're not bound by it. They're not parties to it. They're just witnesses. I have to say, the idea that a contractual obligation would override the disclosure obligation in a criminal proceeding is nonsense anyway, because no contractual obligation could possibly be enforced. It would be an unlawful contractual provision for a contractual provision to say you must not disclose material to a criminal court in the context of criminal proceedings where such disclosure is necessary in the interest of justice. That just wouldn't be an enforceable provision in any contract anyway. But then again, you've got the conflict of interest issue there, haven't you? Because, as I say, the post office had a commercial contractual relationship with its supplier and its software supplier, and that in and of itself for me creates significant issues around whether you should really have private prosecutions by organisations in this way at all. And I'm for my part, don't believe that we should.
At the very least, they were entitled to, they could pay Fujitsu for the information apparently, and they decided that they wouldn't pay for it, and that was also criticised because clearly costs shouldn't be a reason for not disclosing information that they
absolutely
could obtain.
not. No.
Yeah.
No, I mean, it all comes down to the, as I say, that obligation on the prosecutor, first and foremost, is to assure the court, and indeed certify to the court, that everything that could have been obtained and reasonably could have been obtained has been obtained, and everything that reasonably should have been disclosed to the defence has been disclosed. Unless, sort of hand on heart almost, the prosecutor can say that, then they have to drop the case because it's so fundamental to the process. So, you know, and cases in the past brought by private prosecutors have often ended up, the biggest stumbling block for them is the fact that they find it almost impossible to satisfy the disclosure requirements under the Criminal Procedure and Investigations Act, which, as I've described, you know, every single document or every single piece of material of any kind which is relevant to the case has to be scheduled. And that schedule has to be given to the defence. And that's from the start of the investigation, the very beginning of the investigation. Now, police officers who are used to conducting, say, murder inquiries or complex inquiries or fraud inquiries, they have computer systems and they have software and they have everything to populate these schedules of unused material and to ensure that everything goes on. That system fails. Even with the best one in the world, that fails. But at least they have training, they have software systems, they have the ethos in the, you know, around disclosure. It's part of the DNA. There's a disclosure officer in every criminal investigation whose job is to maintain those records. So private prosecutors simply don't have that infrastructure, and that's you know, that's a recipe for disaster.
Would it be reasonable to say, Chris, that a careful prosecutor would have a chain of their own evidence of the sort of inquiries they've asked of their clients to
absolutely.
Yeah.
I mean, not just a careful prosecutor, any competent prosecutor. I mean, you have to have an audit trail of everything that's been done on the investigation, and that log that I described, at what's called a schedule of unused material, that's the kind of audit trail of really what's been gathered. And that even includes things like, you know, if you have emails between an investigator and a witness, or in this case, between the investigators and the software company, those emails themselves need to be included on the disclosure schedule. So correspondence, which is relevant to the investigation. If, you know, if the investigator at the post office or any other private organisation writes to a technical supplier whose equipment has been used to produce evidence, you know, and then they get a reply back, it's about something that's connected to the investigation. It's pretty obvious to most of us that that's going to be relevant to the investigation, which is the test for scheduling on the unused material schedule. And so, but as I say, across the board of criminal investigations of all kinds, one of the first things that I often find when I look at a new file, a new case, is a lot of material that should be on that schedule is not there. And then we have to go back to the prosecutors and say, look, you haven't scheduled, for example, contact between the officers and the witnesses. So all you've done is produce a witness statement. We don't know when the officer met the witness. We don't know what discussions took place. We don't know whether there were 2 or 3 versions of that statement and information came in over a period of time. You don't know any of that because none of that's recorded on your schedule. So you need to go away and do it again. And, you know, there's often a sort of backwards and forwards, and it takes us sometimes many, many months just to get a reasonable degree of comfort that all the unused material is even listed. And then it's a whole different ballgame to make sure that you get everything that you're entitled to. Because just because it's listed on that schedule doesn't mean that it's going to be given to the defence. You know, there has to be a decision as to whether it may reasonably be expected to assist the defence in some way or undermine the prosecution case. So disclosure, as you probably gathered from my fairly long-winded explanations, is not a straightforward matter, but it is a process. You know, if you have the right processes there, you have the right, you know, particularly the right software, templates, you know, reminders, databases, the sorts of kind of software that can allow you to manage data efficiently and not for nothing to slip through the net. It's a whole lot easier than if you don't. I mean, the days when I first started out in practice in the 90s, often disclosure, you know, I went to court on a major case that had been going on for 6 months, and not even that long ago. I think it was about 10 or 11 years ago. And the disclosure officer in that case the judge said, well, where's this particular file of original evidence? And they went away and came back a day later and said, oh, we can't find it. We don't know. And so sort of original evidence was going missing in warehouses, and nobody knew where kind of test results were and things like that. So, you know, the criminal prosecutions are human affairs, and they're susceptible to human error. The post office scandal, I have to say, looks a lot more like cover-up than human error, as far as I can see.
Well, it got worse, of course, because in about 2013, which was several years before the 2019 judgments, the Post Office seemed to have been informed that their expert witness had been untruthful in his evidence, at which point they stopped prosecuting sub-postmasters. But that's where it stopped. So
yeah, they didn't go back and try and unravel the sins of the past.
A whole lot of people had been prosecuted and convicted. Hundreds had been convicted and ruined, but nothing was done apparently to disclose that. And that again must presumably have involved some lawyers giving advice.
Well, who knows?
Who knows? Who knows?
I don't know. We don't know.
But what should happen? I was going to
post-conviction. I've explained the process pre-conviction. Otherwise, if someone's being prosecuted, how the disclosure process is supposed to work. None of that really applies post-conviction. So once someone's been convicted, and they may be in prison or they may not, depending on the sentence. But after conviction, the obligations are much smaller. So but they still exist. And the obligation post-conviction on any prosecutor is to disclose anything which might reasonably be expected to give rise to a successful appeal, either against sentence or more realistically conviction. So if the day after someone's convicted, it becomes apparent that the evidence upon which they were convicted is unreliable or was unreliable, then the obligation is to inform the defence immediately and the defendant of that fact, so that the defence can, as soon as possible, take steps to appeal. And so if there is, if the position as we understand it is right, that as early as 2013, the Post Office was aware that that many had been convicted on the basis of unreliable evidence, which was central to the case, and that's really quite important. Then the obligation was to immediately write to anybody who conceivably may have been affected, making complete and transparent disclosure of what had happened, and suggesting that whoever the defendant was should seek legal advice with a view to a possible appeal. That's what should have happened. If in fact also it became so clear that the convictions were unsafe, or some of them, then the obligation, it may well be on the prosecutor to restore the matter before the court of its own motion, regardless of the defence, and invite the court to quash the convictions. Because if a prosecutor becomes aware that a conviction is unsafe, then that prosecutor, can and should take steps to reverse the position and reinstate the person to the status they should have had as much as possible, i.e. that they shouldn't have had the conviction. It should be quashed. If you think about it, also that kind of mitigates the likely damages, because, as you know, there was a large civil settlement involved with many of those who were affected by these issues. Well, if the Post Office had taken early action to remedy the problem, that would have reduced the scope of any damages award, because they would have done everything they could. Once it became apparent that there was a problem, and once it became apparent in particular that people should not have been convicted, and thereby therefore they should have their convictions quashed, the earlier that the Post Office took action, the more they would mitigate the position of the Post Office in terms of damages awards, because they would have done, at least far too late, but they would have at least set the record straight. Here, as you know, the Post Office really didn't even act promptly when they were faced with an overwhelming position that their evidence was unsafe on a number of grounds, and that's one of the many reasons why they have been so heavily criticised as a result of, by judges amongst other people in the course of various judgments in the cases that have followed.
In fact, I don't think they took any action at all. Even when the appeals started, they simply said they wouldn't oppose the appeals. They didn't. Yes. They didn't disclose the fact that they knew perfectly well that the appeals should succeed, because they had this information back in 2013. It was only because that information then fell out in the course of the appeal process that it was exposed.
It's a surefire way to get significant judicial criticism, to expose the organisation to significant litigation risk, and potentially to expose those individuals who may have been knowingly culpable in covering up material that was relevant to appeals or indeed trials earlier in the sequence, to potential liability themselves for example, perverting the course of justice.
So the criminal charges, we don't know who, we're not saying anyone, but if people are being investigated, what is that the only charge that is reasonable, or are there others?
The most obvious one would be perverting the course of justice, because that's a fairly broad brush, which says that anyone that does an act tending and intended to pervert the course of public justice commits an offence, and it's a serious offence and can result. I mean, it's a common law offence, so it can result in theory life imprisonment. But the reality is sentences are generally not as long as that. It very much depends on the facts of the case. But that's the most obvious one. So just sort of take it away from this case. But if you, as a police officer, for example, if you did get that, he took a witness statement from someone, who said, I saw the murderer, the guy running away and he had ginger hair, and you thought, well, that's no good because we've got the other guy in custody, and ripped it up and threw it in the bin. That's perverting the course of justice. That's, you're doing an act tending to pervert the course of justice because it tends to implicate someone who's actually innocent, or at least it withholds information that may cast doubt on guilt. And it's intended to do so. It's the deliberate act of covering up and of destroying the evidence. So accidental or negligent breaches don't amount to perverting the course of justice. It has to be intentional. But there are others, of course. If you make a false witness statement, that could be perjury. Or a false witness statement could be both. It could be perjury and perverting the course of justice. So even giving information to your own barrister that you know to be false, which the barrister is then going to pass on to the court, that could be perverting the course of justice, because there's a chain of causation between false information given to the lawyer and then the impact on the course of justice in the form of the legal proceedings. So, in any individual case, the key issues are, did what this individual person did, so you can't look at it as an organisation. When it comes to criminal charges of this kind, did the individual know that what he or she was doing had a tendency to pervert the course of public justice in the form of criminal proceedings or criminal prosecution? And if he knew that that was the case, did he intend that should happen? And, clear-cut cases of withholding information that would have been decisive to guilt or decisive to an appeal, for me, could certainly fall into that category. But it all depends on the actions and the evidence of the actions of individuals.
So, do you think the courts have a low threshold for being concerned about perversion of the course of justice, or a high threshold? It sounds quite difficult to prove, in the sense you've got to prove an intent, which may be difficult and therefore make people reluctant to pursue it. But is this something the courts are very sensitive about, or does a lot get passed? Which is
there are not that many. There are not that many prosecutions for perverting the course of justice arising from misconduct in the conduct of prosecutions. So by police officers or lawyers, it's quite rare because, as you say, it is quite difficult to prove intent. It sometimes can be quite difficult to prove knowledge. If someone relies on sort of, I acted in good faith because I was told this by someone else, then that is a defence, of course, because you can't, it depends on whether it's a reasonable position to take or not, but that would be a defence. So it's quite tricky. I mean, usually perverting the course of justice is in fairly clear-cut cases. For example, forging witness statements, or, in the case of, a murder investigation, son comes home covered in blood and mum washes his jumper, to get the blood out of it. Those are the kind of really quite obvious examples where the action is clearly has a tendency to pervert the course of justice. They clearly intended to do so. When it comes to disclosure decisions, it's quite nuanced and difficult. So there are actually very few cases of prosecutions for perverting the course of justice. One of the more high-profile ones I was involved in myself was the Hillsborough case, where a solicitor and 2 police officers were prosecuted, and I represented one of them, but they were all acquitted. And indeed, the judge directed that there was no case to answer in that case. So it is actually very rare to have lawyers or investigators prosecuted for perverting the course of justice, and when it does happen, it's usually in really clear-cut circumstances, because otherwise, it will be difficult to get over the threshold of prosecution because if the case is vague, you can't really pin anything on an individual with any clarity, then as a prosecutor you can't bring that case because you just don't have a sufficient basis to believe that there will be a conviction.
What about shredding documents?
Yeah, I mean, shredding documents that are relevant to an investigation it with the intention of making relevant evidence disappear is plainly perverting the course of justice. I mean, it's as clear as day, provided the intent and the intention's there. I mean, if Office Junior is told by his boss, go, these are old files, just shred them, doesn't know anything about why they're being shredded, then it's not the physical act of shredding, it's the tendency of the shredding and the intention behind the shredding. But yeah, I mean, shredding is the classic example of perverting the course of justice when it's done to get rid of awkward pieces of evidence by police officers or other investigators.
What do you think? Would the court be affected by the fact that everybody knows that this is the largest miscarriage of justice, that we've ever had in this country, and so many people have
it's
gone
all
to
relative,
prison?
isn't it? It's difficult to quantify in terms of number of defendants. Then certainly, I think that must be right. I mean, I guess it all depends on your perspective as to whether it's the largest. But yes, but your question is, does the fact that it's happened on a large scale, is that going to influence?
Well, not conviction. I don't mean conviction, because obviously you have to prove it as it's required. But if somebody is found guilty, do you think that would have a bearing?
Yeah, absolutely. So if you were to, for argument's sake, were to, act dishonestly and pervert the course of justice to get someone a speeding ticket, when they didn't really deserve one, that would still be serious if you're a police officer and, still carry serious consequences. But ultimately, the consequences to the person of just getting a speeding ticket are not at the top end of the scale. But seeing dozens of people sent to prison as a result of perverting the course of justice, that would result in a very long prison sentence if that were proved as perverting the course of justice by any individual. You'd see them go to prison for many years. It's
a hard job for the defence if you've got an organisation that's prepared to throw money at and this kind of lawfare is the jargon now, isn't it, for doing anything to thwart a defence or to win a case. Are you coming across that much? Are you coming across that an approach to legal cases where
scorched earth policy,
this so-called scorched earth policy is being applied?
I mean, I'm sadly, you do see it not just in, private prosecutions, but in public prosecutions. You do see a kind of cynicism amongst prosecutors and a kind of dogged determination to pursue the original case theory that the investigators may have had at the very beginning, right the way through the investigation, right the way through any court proceedings, whatever the evidence actually shows. So that kind of single-minded or narrow-minded determination to stick to the prosecution's guns at all costs. That's always been a feature of certain prosecutors and certain kinds of prosecution. Likewise, as I say, if you want to try and be fair and balanced about it, there has also been, a rich vein of kind of legal practice, defence practice involved in deliberately trying to do anything to scupper a prosecution by making any number of, spurious disclosure applications or applications of all sorts of other kinds to exclude evidence and so on, which are intended to derail the case and distract from the core issue of what the evidence proves against the defendant. So, that's the opposite kind of end of the spectrum, if you like. So you've got, kind of blind determination to prosecute and to get a conviction come what may at one end, and you've got kind of like blind determination to secure an acquittal or to at least to get the case kind of derailed in some way, shape or form at the other end. And neither of those are acceptable forms or proper professional forms of conduct for criminal lawyers. We're all bound by the criminal procedure rules and our own professional obligations, which, as I say, are first and foremost to the court and to the interests of justice. And so, we're not entitled, or nor should we, on either side of the fence, kind of just use and abuse, the various applications and systems available to us for improper kind of ends. Do
you have a sense that senior judges have an appetite, though, for trying to sort that out, Chris?
Yeah, we do. We have come a long way in some. In some ways we've gone backwards, particularly in terms of resourcing in the criminal justice system for investigations and prosecutions and defence and the courts. Huge problems in those areas. But in terms of kind of pragmatism and trying to get to the point, judges and the criminal procedure rules and the practice directions are all intended to narrow issues to move things along in a sort of sequence when it comes to criminal prosecutions, to shake out of the tree any disclosure problems or legal problems or other problems fairly early on in the process, So the system has developed. The difficulty, of course, with any system is that it's only as good as the ingredients, and the ingredients are the lawyers and the police officers and the investigators and so on, and the judges. So judges are overwhelmed by the volume of work, particularly in the Crown Court. There is a huge backlog, as you may know, in the Crown Court, well over 60,000 cases, and so judges are under enormous pressure. So we, I often have clients saying, well, can we have a hearing in front of the judge to talk about this, that and the other? And I'm saying, well, we probably have a hearing, but he's going to have 15 minutes. He's not going to give us all day to talk about this, because he just doesn't have all day to talk about it. So judges, even if they have the best of intentions as far as ensuring that the rules are followed on both sides, may not have the pure time available to read the papers properly, to think about the case properly, and to listen to the sorts of applications and arguments that may be needed. There's a world of difference between the criminal justice process and, for example, in the Chancery Division, or in relation to commercial practice, where it's effectively self-funded on both sides, and the parties have almost unlimited time to engage in whatever they like. So but all of that brings us back to where we started, in my view, which is the system only works if prosecutors in particular, but also defense lawyers, act responsibly and follow the obligations upon them. So if any lawyer colludes with the withholding of evidence, or the making of spurious applications that are going to waste the court's time, then that lawyer is part of the problem. And judges are quite alive to that, and when they do see manoeuvring of one kind or another, or if they see a complete lack of engagement by the prosecution in considering reasonable requests for disclosure, then judges do get quite cross and will seek to put that right. But they can only act on what they're told and what's put before them. They can't judges are not investigators. They can't go out and find things for themselves. So therein again lies the problem. The system is only as good as what you put in.
It doesn't sound as though professional organizations or regulators are going to play much part in reining in that kind of unreasonable behavior.
I mean, that's true, as I say, because we have all of these rules about our obligations, but I don't necessarily see on a day-to-day basis that those rules are operating to have any huge effect in terms of the way people kind of behave as lawyers. I think we were all brought up and trained on the sort of ethical rules. That's part and parcel of our professional training, and we are expected to be on top of that in terms of our professional development, and we're supposed to have a good knowledge of kind of ethical considerations, including in criminal cases when it comes to our obligations separate from our obligation to our clients. But I think many lawyers, they have over the course of time, particularly if they've been in practice for some time, our standards are set by the time we've been in practice for sort of 10 to 15 years, and sadly, some occasionally fall short of what is to be expected. Some fall short regularly, and very occasionally they fall foul of the regulator, the Bar Standards Board in my case, and they may face disciplinary action. But that's a very small number of people in the grand scheme of things. When you think about the number of cases and the number of occasions upon which there have been scandals as far as disclosure and various other forms of misinformation being given to courts are concerned. Whether an increase in regulatory activity and increased scrutiny by regulators is really the answer, I think I struggle with that, really, because I think those of us who sort of practice ethically, we do so without thinking that's because of paragraph 4B of the Bar Code of Conduct. We do it because it's in our sort of professional DNA. And so I'm not sure that just being required to be shouted at by a regulator every month or two and told what the rules are for the 150th time would make any difference to me, or indeed to someone who was minded to bend the rules. If people are so minded, and I'm sure they exist, I really don't think that the regulators can have much to say about it in advance. But regulatory action when it becomes apparent, particularly in a high-profile case, that lawyers have fallen short of their professional obligations, I do think there's a sort of argument for some sort of regulatory enforcement, because there's nothing more sort of almost embarrassing or humiliating for a lawyer than to be publicly kind of identified as someone who's been guilty of professional misconduct. And the consequences may be very serious. So I do think if someone has fallen far short of their professional obligations, and as part of that failing has led to wrongful convictions, then I think there should be consequences.
And finally, Chris, what about private prosecutions? Are they on the rise or are they falling?
Oh, they're massively on the rise. So we've seen a huge reduction in the budgets for investigation agencies, particularly in terms of fraud, particularly at the CPS, which has seen massive cuts also across the whole of policing. So what we're seeing is that cases that in the past, particularly large-scale financial fraud cases committed against corporations, the corporations are just giving up on the idea of using the Serious Fraud Office, for example, or the police to pursue those cases in favour of just prosecuting themselves as private prosecutions. And there are a number of law firms around now which specialise in advising individuals to some extent, but also corporations on the use of private prosecution to effectively to achieve commercial aims, compensation or recovery of losses. And that can be an effective tool. There have been a number of successful private prosecutions. They do always carry the risk that they won't comply with the rules that affect investigations and disclosure. But that's a risk that corporations are willing to take. It's a slippery slope. Once you have sort of two separate, sort of almost like a completely two-tier system of prosecution, the sort of public prosecution, which you might equate to the NHS, and then the private prosecution that you might equate to private medicine. One's on a fast track, everything happens more quickly and so on, and the other one is perhaps falls behind in terms of its capacity and its effect. And I think for me there's something unsatisfactory about the idea that wealthy corporations, or wealthy individuals for that matter, can use the public criminal justice process to achieve their own commercial or personal ends. I think there are risks attached to that, and there need to be very significant safeguards. But at the same time, I do advise clients on private prosecutions, and I do think in the end, I think the fact that we as British citizens and corporations have the right to bring private prosecutions, I think is quite important. I don't see that there's anything being fundamentally wrong in principle with that. The difficulty is policing how exactly those private prosecutors go about their work, and in particular ensuring that there is full disclosure of anything that might undermine the case that's brought. That's very, very difficult. But ultimately, the courts are there to try to referee that process. But there's not as many courts as there used to be, and judges don't have that much time to do it. So very significant risks here. And I do think that there would be the benefit to have perhaps a more clear statutory scheme for how private prosecutors, and certain boxes that would have to be ticked before a private prosecutor could even bring a case. For example,
be authorised to, you mean, be authorised as prosecutors?
At the moment, there's no requirement for authorisation. Anyone could, I could prosecute you two for almost anything I wanted on the back of an envelope. So there's almost no control. So I do wonder whether it might be wise to have a system whereby you would have to apply to a magistrate or to a Crown Court judge, depending on the nature of the case, for permission to bring the case. And before that happened, it wouldn't be about looking at the evidence, whether you prove it the case or not. But before that happened, you'd have to demonstrate that you had in place the systems to ensure proper disclosure would be made to the defence. And if you couldn't do that, you'd be sent away until you could. And then you'd have maybe come back again in 6 months and say, look, Judge, we put it all right now. Can we now issue our case? And I think that kind of safeguard, particularly in cases where there's a real risk of imprisonment, I think would be something that would be worth thinking about.